Hi everyone, my name is Kuldeep Jauhari. I am a practicing lawyer and I am here to help you understand legal procedures and legal mechanisms. And in furtherance of that, I am going to talk about the law of anticipatory bails in India or the pre-arrest bail या फिर हम इसे हिंदी में अग्रिम जमानत बुलाते हैं. Now, what is an anticipatory bail? There are two kinds of bail. One is a regular bail, which you seek once you are already in custody for as an under trial or maybe during the preliminary stages of the investigation. The other is the anticipatory bail, which is also your right and which saves you from going into that custody, which nobody likes. And there are for to understand the law of anticipatory bails, we will also have to kind of understand that what are the kinds of offenses or what is the classification of offenses in India. So broadly classifying, there are two kinds of offences in India. One is defined under the category of a bailable or a non-bailable offence, and the other are cognizable and non-cognizable offences. So each offence under the IPC or the Indian Penal Code has either of these two. It has to be a bailable or a non-bailable offence, and it has to be either a cognizable or a non-cognizable offence. This is their classification. Now, to understand what is a cognizable and what is a non-cognizable offence, a cognizable offence is one in which the police, just on the mere receipt of information of the commission of such an offence, can on their own investigate into that and start collecting evidence on that. A non-cognizable offence, on the other hand, is one where the police, though receives information, but for investigating into that offence, they will have to seek the permission of the court. And only upon the court's approval can they further investigate in that matter. Now, bailable and a non-bailable offence, unlike as the name suggests, there is a slight confusion about in the minds of the general people about bailable and non-bailable offences, which is that in case it is a non-bailable offence, there is no way or there is no chance that you can get a bail in that offence, which is not so. So the difference between a bailable and a non-bailable offence is that a bailable offence, you are entitled to get bail as a matter of right, and in a non-bailable offence, you will have to approach the court to seek bail. So to differentiate, it is like if you are accused in a bailable offence, so the arrest that happens will only happen on paper and you will be granted bail there and then by the police officer itself. You don't need to approach the court. You will only have to furnish a bond, a personal bond or a security bond to secure your bail and to probably keep it as a security that you will not commit this offense in the future. And in a non-bailable offence, you will definitely have to go to the court to seek bail. The police does not have the power or authority to grant you bail in a non-bailable offence. So that is the broad classification of offences. Now, say for instance, the police receive an information against you, and the information that is received constitutes an offence which is both cognizable and non-bailable. So now it is the police's right, and it is in their authority to arrest and apprehend you so as to complete their investigation. But while they have their authority, you also have your right, which is your right of anticipatory bail, which is that you can go to a court of sessions or the high court, and which is provided under the law, which is provided under section 438 of the criminal procedure code, which says that you may either approach the court of sessions or the high court. But as a matter of from what I have seen, it is always good to exhaust your initial remedy, which is the sessions courts, and then go to the high court. And you can go to the court, you can file your anticipatory bail application where you can say that this is the offense which has been alleged against you, and it is a completely false claim that is being made against you, and you are ready and willing to join investigation, which is the most important part. You have to prove your bona fide to the court and show that you are not evading the process of law. You are ready and willing to join investigation as and when directed, but there is no purpose that will be served by your custody, and there is no need for your custodial interrogation. Because what happens in a lot of cases is that the IO will receive information against you, he will register an FIR, and then he will start creating that pressure upon you, and then he will start contacting you to come and join investigation. Now, if you have an anticipatory bail with you, there is no way that he can arrest you since you have a court order with you. But if you don't have that anticipatory bail with you, and even if it does not require a custodial interrogation, just to have that gratification, that monetary gratification to extract that from you, the IO will create that pressure that he will want to take you into custody. So it is very prudent for you to. And another thing is that if in case you do not join the investigation on multiple occasions and then you apply for anticipatory bail, then there is a very good chance that the court will not allow your anticipatory bail, because the IO will come and he will submit that he has summoned you so and so many times to come and join investigation, but on every occasion you have not turned up, and which again becomes a reason for the court to reject your bail and tell you that since you're not joining investigation, this is not a fit case for anticipatory bail. So the most prudent way to go about it is that as soon as it comes in your knowledge that there is a case that has been filed against you, there is an FIR that has been registered, you go to the court and you file an anticipatory bail. And on the very first instance, even before, I mean, maybe you could have been contacted by the IO just once, and that is when you have to go and apply for your anticipatory bail so that you get it, and then you are there to join investigation and face whatever comes. But at least you will save that part of going into custody for no reason. So I hope this video will help you, and I will make more of such videos. And if there is any query or any suggestion that you have for me, please put it in the comments below and I will reply to it. Thank you so much.